You have the right to remain silent.
But we'd prefer if you didn't.
Spinning the law, spinning the law.
This is Malzberg's
Spinning the law.
Spinning the Law
Spinning the law, spinning the law.
with attorney Kendall Coffey.
All right, folks, we welcome you back to the Big Steve Malzberg Show, and we say hello to the one and only Kendall Coffey. Hello, sir.
Hey, Steve. How are you? Happy Friday.
Happy Friday. It is Friday, and it's beautiful out here. I assume wherever you are, it's pretty nice out?
Spectacular. Looking at some Atlantic Ocean and some sailboats right now.
Nice. Very nice. Well, I appreciate you. I appreciate you including me in that that whole, puzzle or whatever it is, painting. Anyway, okay, let's talk a little bit about, of course, the Supreme Court decision that came down earlier this week, knocking down or basically what it did was it upheld the right of the people of Michigan to decide to knock down racial quotas as a tool for admissions into their universities. And
there was a very energetic, perhaps passionate dissent by Justice Sotomayor. It was a 6-2 decision. Justice Kagan did not appear. But what was interesting is you didn't have just 5 Supreme Court justices in favor of the result. You had Justice Breyer,
who
6. We recall was an appointee of President Clinton. And the message really was that states can make some choices in this area. That it's certainly not an easy, subject for anybody, but that, as I think Justice Kennedy put it well, the issue really wasn't do you have, is it a good thing, is it a bad thing to ban any consideration of race as was done by the state of Michigan with respect to university admissions, but isn't that something that could be within the prerogative of the state? So, for example, if a state wants to have some consideration of race, not as a quota, but as a plus factor, should the state have the right to do that? And if a state wants to completely eliminate any use of racial preferences in university admissions, shouldn't that be within the prerogative of the state? So, kind of the bottom line was that it really is seen by Justice Kennedy and the majority of the court. It's not about racial preferences, but how that issue should be resolved. And again, the decision that the court made is it should be decided by the people of the state. We emphasize this isn't a case where there was evidence of past discrimination and that this might affect a remedy. This was a situation where this is what the state of Michigan decided. It was upheld. It's an important decision, Steve. I think other states may consider following it. But in some ways, it's a landmark. In some ways, it's expected.
Well, let me ask you this: why does it then not extend to? And maybe I'm jumping to a conclusion, but this is from everything I've heard and read. Why does it then not extend to, let's say, the right of a state to have a Prop 8 in California? I know it's a different issue, but is it not the same state's right kind of an issue where the people have decided this is how they voted and they have a right to, or how is Prop 8 different than this prop that was voted on by the people of Michigan?
Well, I mean that's a fair question. As we know, Justice Kennedy, often the swing vote, had written an opinion that struck down something somewhat similar in Colorado, in the sense that but affecting gay rights laws. Mm-hmm. I think that the Supreme Court has simply reached a point with respect to our history where some of them think, and Roberts, Chief Justice Roberts, has a very quotable comment as well, that we've reached a point where forms of quotas with respect to racial and other minorities, ethnic minorities, are simply not something that is required. It's almost a policy decision. It's a view of history. It's not necessarily strictly speaking a view of the Constitution. You recall that Justice O'Connor had said that there should be some form, in her view, of a plus factor for at least another couple of decades. This court seems to be reaching the conclusion a little faster in terms of watching the flow of history.
So was
that,
this? I'm sorry to interrupt. I'm sorry to
No,
interrupt.
no,
So was this a decision based on the court's view of affirmative action, or was this a decision based on that said they had the state of Michigan had a right to vote on this, and they voted on it legitimately, and it'll stand because they have a right to decide these kinds of things, and do they and obviously they distinction and make between racial quotas and gay marriage. I mean, no?
There seems to be such a distinction. I think this would be, as the Supreme Court described it, a decision that's based on the prerogative of the people of the state to make that kind of decision in this very difficult area. But I also think that it's consistent with a judicial momentum, and I would not be astonished at all to see a further approaches with respect to the subject of affirmative action over the next 5 years. I think that at some point it's going to be reconsidered again, and I'm not sure that any form of racial preference is going to survive the next treatment.
And I hope not, but let's keep in mind that, God forbid, in my view, President Obama gets to replace the swing vote and maybe a conservative justice between now and the end of 3 years, and then all bets would be off, I think.
Well, I think the 2016 election is going to kind of decide that. I'm not sure anyone's expecting any retirements between now and then.
No, not expected, but the unexpected.
The
yeah.
2016